When I read the statement made by Justice Thomas, joined by Justice Alito, in the case of Davis versus Ermold, well, I saw evidence that a government of the people, by the people, and for the people appears to have perished from the earth. So we'll discuss that next on the Constitution Study.
There's one thing you have to know wherever you make your stand. Came from a long through line of everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution and we teach the rising generation to be free. I am glad you could join me today. You know, it's wonderful to spend some time and put these messages together, record them, and share them with you. I hope you find them useful. I hope you're sharing them. I hope you're taking this information, sharing it with friends and family. That's really rather important. I'm putting out as much information as I can. Now, while I've recorded this early, by the time this airs, I would have just put on my webinar on the presidential elections. I know you're probably burnt out on everything presidential election, but follow me for just a little bit. See, for the last several weeks and even months, I've heard a lot of misinformation and just plain mistakes about how we actually go about electing a president. So I put together a webinar and I went through the actual process, including why we have an electoral college. Most importantly, I included what happens if things don't go smoothly. If votes aren't tallied on time in the states, or if a state doesn't get its paperwork together, what actually happens? Now, why do we bring this up if the webinar's already happened? Well, if you didn't get a chance to register, you could still go register now. So I'm keeping registration open through Election Day, and you'll get a recording of that webinar. So even if you missed it, even if you forgot to sign up, you can sign up today through Election Day, and you will get a recording of the event that you can refer to. And you'll also get my PowerPoint, my presentation, so you can review that as well. So please head over to the website, constitutionstudy.com/election, register, and you'll get that link for the recording of the webinar. So let's talk about this unique statement. The Supreme Court recently denied the petition for a writ of certiorari, or for the court to hear, in the case of Kim Davis versus Ermold. Now, you may remember this as the case of the Kentucky County Clerk who was sued because she refused to issue marriage licenses to same-sex couples. Reading Justice Thomas's statement not only showed how badly that case was decided, but the discrimination that it has brought about to our nation. Now, you may be asking yourself why I'm reviewing a 5-year-old case. Because that recent case of Davis versus Ermold gives evidence not only of how bad the Obergefell decision was, but how the entrenched dogmatic devotion to precedent prevents the citizens of this country from obtaining justice from what we euphemistically call our justice system. Justice Thomas took the somewhat unique position of writing a statement on the court's decision to not grant cert. Quote, in Obergefell versus Hodges, the court read a right to same-sex marriage into the 14th Amendment, even though that right is found nowhere in the text. Now, whether you believe same-sex marriage should be legal or not, the question I want to look at is how this came about and the easily anticipated consequences of the court's opinion. Quote, Kim Davis, a former county clerk in the Commonwealth of Kentucky, was responsible for authorizing marriage licenses. Davis is also a devout Christian. When she began her tenure as clerk, Davis sincerely held religious beliefs that marriage exists between one man and one woman corresponded to the definition of marriage under Kentucky law. You see, when Ms. Davis took the job as county clerk, there was no division between what she believed and the laws, both in Kentucky and the United States. However, that was about to change. Within weeks of this court granting certiorari in Obergefell, Davis began lobbying for amendments to Kentucky law that would protect the free exercise rights of those who had religious objections to same-sex marriage. But those efforts were cut short by this court's decision in Obergefell. Notice, Ms. Davis did not try to stop those who wanted same-sex marriage from petitioning their government or to stop the government from enacting same-sex marriage laws. What she wanted were legal protections for those who had religious objections so that all the people of Kentucky could retain their freedom to worship, and not just in churches, but anywhere. This would also include the freedom to speak and the liberty to live their lives as they see fit without government interference. The need for such protections would soon become apparent. Quote, as a result of this court's alteration of the Constitution, Davis found herself faced with a choice between her religious beliefs and her job. When she chose to follow her faith and without any statutory protections of her religious beliefs, she was sued almost immediately for violating the constitutional rights of same-sex couples. There are a couple things worth pointing out in this part of Justice Thomas's statement. First, while Ms. Davis did face a choice between her religious beliefs and her job, it's worth pointing out that it was a government job. That government that was created by the Constitution of the Commonwealth of Kentucky, and a government regulated by the constitutions of both the Commonwealth and the United States. Second, and more importantly, Justice Thomas notes that the court effectively altered the Constitution, creating a new right that people were using against Ms. Davis. Now, as I've already quoted from Justice Thomas, the court had found a right in the 14th Amendment that does not exist in the text. That this would cause problems should have been a surprise to no one. It certainly didn't surprise some of the members of the Obergefell court. Quote, several members of the court noted that the court's decision would threaten the religious liberty of the many Americans who believe that marriage is a sacred institution between one man and one woman. If the states had been allowed to resolve this question through legislation, they could have included accommodations for those who hold those religious beliefs. The court, however, bypassed that democratic process. First, America is not a democracy, but a republic. So technically, the court violated the republican process. Webster's 1828 dictionary defines a republic as a commonwealth, a state in which the exercise of sovereign power is lodged in the representatives elected by the people. Not only did the court violate the republican process, but the very Constitution itself. They not only placed their opinions above the law, but above the will of the people as expressed in the constitutions of the Commonwealth of Kentucky and of the United States. The U.S. Constitution does not give the United States the authority to define marriage, and neither does it give the judicial branch the authority to rewrite or reinterpret the Constitution. Only the states have that power. By depriving Congress of their legislative power as defined in Article 1, and the states of their power to legislate what is not delegated to the United States as protected by the 10th Amendment, the Supreme Court effectively usurped the levers of power in this country. The majority violated both their oaths of office to support the Constitution of the United States and the terms of their office by behaving so badly. See, Article 3, Section 1 of the Constitution says, the judges, both of the Supreme and inferior courts, shall hold their offices during good behavior. Not only did the court usurp power, but they slandered millions of Americans with strongly held religious beliefs. Quote, worse still, though it briefly acknowledged that those with sincerely held religious objections to same-sex marriage are often decent and honorable, the court went on to suggest that those beliefs espoused a bigoted worldview, noting that such a view of marriage is demeaning to gays and lesbians because it teaches that gays and lesbians are unequal, describing the view of marriage dictated by the religious beliefs of many as imposing stigma and injury, and characterizing the traditional view of marriage as disrespectful to gays and lesbians. While I do believe that anyone should be able to live their lives as they see fit, as long as they do not infringe on the legitimate rights of others, the language of Obergefell not only slandered millions of Americans, but also had the quite obvious effect of doing to faithful Christians, Jews, and Muslims and others exactly what the court claimed the traditional view of marriage did to gays and lesbians. Quote, the dissenting justices predicted that these assaults on the character of fair-minded people will have an effect in society and in court, allowing governments, employers, and schools to vilify those with these religious beliefs as bigots. Those predictions did not take long to become reality. Which brings us back to Davis v. Ermold. As expected, the damage done by Obergefell did not stop with that opinion. Quote, Davis may have been one of the first victims of this court's cavalier treatment of religion in its Obergefell decision, but she will not be the last. Due to Obergefell, those with sincerely held religious beliefs concerning marriage will find it increasingly difficult to participate in society without running afoul of Obergefell and its effect on other anti-discrimination laws. Moreover, Obergefell enables courts and governments to brand religious adherents who believe that marriage is between one man and one woman as bigots, making their religious liberty concerns that much easier to dismiss. For example, relying on Obergefell, one member of the Sixth Circuit panel in this case described Davis's sincerely held religious beliefs as anti-homosexual animus. In other words, Obergefell was read to suggest that being a public official with traditional Christian values was legally tantamount to invidious discrimination toward homosexuals. This assessment flows directly from Obergefell's language, which characterized such views as disparaging homosexuals and diminishing their personhood. Since Obergefell, parties have continually attempted to label people of goodwill as bigots merely for refusing to alter their religious beliefs in the wake of prevailing orthodoxy, for recognizing the plaintiff's argument equating an accommodation allowing religious objectors to rescue themselves from signing same-sex licenses with impermissible discrimination, or describing owners of a wedding studio who declined to participate in same-sex weddings for religious reasons as treating homosexuals like social outcasts. The Obergefell opinion is not only being used to discriminate against the free exercise of religion, but the right of Ms. Davis to worship God according to her own conscience. Section 5 of the Bill of Rights of the Kentucky Constitution reads, "And the civil rights, privileges, or capacities of no person shall be taken away or in any wise diminished or enlarged on account of his belief or disbelief in any religious tenet, dogma, or teaching. No human authority shall, in any case whatever, control or interfere with the rights of conscience." This opinion can also be used to effectively create religious tests for those who wish to work in U.S. government. See, by requiring that someone compromise their faith in order to receive employment, we now have a religious test disguised as compliance with a judicial opinion. This is a direct violation of Article 6 of the U.S. Constitution, which reads, "But no religious test shall ever be required as a qualification to any office or public trust under the United States." Now, after watching all of this, I'm sure most of you would conclude that Justice Thomas, who dissented in the original Obergefell case, well, he would be ready to revisit that decision. Quote, "This decision implicates important questions about the scope of our decision in Obergefell, but it does not clearly present them. For that reason, I concur in the denial of certiorari." See, Justice Thomas does not tell us what the confounding issues were in this case, only that it wasn't clean enough for him. After reading the aftermath he has already quoted, I wonder what it would take for Justice Thomas, and Justice Alito for that matter, to agree to the court reviewing, much less overturning, that opinion. Quote, "Nevertheless, this petition provides a stark reminder of the consequences of Obergefell. By choosing to privilege a novel constitutional right over the religious liberty interests explicitly protected in the First Amendment, and by doing so undemocratically, the court has created a problem that only it can fix. Until then, Obergefell will continue to have ruinous consequences for religious liberty." While I disagree that the court has created a problem only it can fix, I have to wonder about a justice who is unwilling to stand up, even in a minority, and call for the court to review what's being done to the people of America as a consequence of their opinion. Why do I say the Supreme Court is not the only fix for this problem? Because the Constitution does not delegate to the court the authority of final arbiter of what's constitutional. In fact, the Constitution does not delegate the power to the federal government to have final say on what the Constitution says or means. That's a power reserved to the states. The 10th Amendment says the power is not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. Furthermore, the courts have no power to enforce their decisions. They are dependent on the executive branches of both the state and federal government to act on their opinion. Quoting Alexander Hamilton in Federalist Papers number 78, "The judiciary, on the contrary, has no influence over either the sword or the purse, no direction either of the strength or of the wealth of society, and can take no active resolution whatever. It may truly be said to have neither force nor will, but merely judgment, and must ultimately depend upon the aid of the executive arm, even for the effective efficacy of its judgments." See, it's only our slavish devotion to placing the opinions of courts above the actual law that give these judges any power at all. We have hired executives that have given over their control of the sword to the courts that grants them strength. And it's the fact that we have hired representatives who have delegated their power to legislate that have given the courts their will. It's time we return the Constitution to its rightful place as the supreme law of the land and relegate what comes out of the courts back to the role of opinion only. If their opinions are good, if they seek justice within the confines of the laws we the people and our representatives have created, then they are worthy of consideration. If not, then they should be thrown into the trash heap of history, just as we have done with the Dred Scott opinion. Now, there are some that will call me an anarchist or claim I'm trying to subvert the rule of law for what I've said. They will claim I'm promoting civil disobedience or a desire to overturn our government. On the contrary, I'm suggesting we uphold the rule of law, including the law that limits the power of the branches of the federal government. I want to restore order and justice to a system that has become as tyrannical as the one we overthrew 244 years ago. I want all Americans to uphold the law. According to the words of Alexander Hamilton, quote, "There is no position which depends on clearer principle than that every act of a delegated authority contrary to the tenor of the commission under which it is exercised is void. No legislative act, therefore, contrary to the Constitution can be valid. To deny this would be to affirm that the deputy is greater than his principal, that the servant is above his master, that the representatives of the people are superior to the people themselves, that men acting by virtue of powers may do not only what their powers do not authorize, but what they forbid. If both the legislature and the judiciary swear or affirm to uphold the Constitution, would not a judicial act contrary to that law be just as invalid? Or as Chief Justice Marshall put it in the Marbury versus Madison opinion, if an act of the legislature repugnant to the Constitution is void, does it, notwithstanding its invalidity, bind the courts and oblige them to give it effect? Or in other words, though it be not law, does it constitute a rule as operative as if it was a law? This would be to overthrow in fact what was established in theory, and would seem at first view an absurdity too gross to be insisted upon. Thus, the particular phraseology of the Constitution of the United States confirms and strengthens the principle supposed to be essential to all written constitutions, that a law repugnant to the Constitution is void, and that courts, as well as other departments, are bound by that instrument. Would not an act of the judiciary repugnant to the Constitution be just as void? Then what I'm calling for is not civil disobedience, but peaceful noncompliance with an opinion which not only is devoid of the force of law, but is, by its violation of the Constitution, void. So I hope you'll forgive me for taking you down memory lane. Some of you may want to forget Obergefell. But what we see here is a couple of things. We are seeing the consequences of not only a poorly decided opinion, but a poorly written one. One that not only elevates the opinion of judges above the actual law, that puts judges in the place of the legislature and we the people when it comes to crafting our policies, but one that goes so far as to slander the American people in doing so. But we also see a justice who sees the problem, but for some reason isn't willing to confront the problem. Oh, he's willing to talk about it. He's willing to make statements about it, but he didn't vote. And I don't know why. Now, I may be willing to give Justice Thomas a little bit of leeway. I don't know the reasons why he decided to deny cert. I only know that he did. I only know that he saw what appears to be a terrible opinion with terrible consequences, and he voted not to try to deal with it. But that's between him and his maker. I hope you'll see the importance not only of recognizing the limits of the judiciary, but recognizing the responsibilities of we the people and the states when it comes to dealing with the federal government. The federal government has very limited powers. We talk about checks and balances between the branches of the federal government, but remember, the states are there to check the federal government's power. That is why the federal government cannot amend the Constitution. Only the states can. Oh, they can propose amendments, but it's ultimately the states that ratify and make them effective. So maybe it's about time we started talking to our state legislatures, our state executives, all of our state elected officials, the people we hire to represent us, to exercise our power in our name, and tell them to do their job, to protect the rights that we have given them. That's right. We, the people, when we wrote the constitutions, when we ratified the constitutions of our states, gave those states powers. We gave them rights. It's about time we tell them, you need to stand up for those rights. For over 100 years, the states have been giving away their power, their rights, and we, the people, have let it happen. And it's about time we start changing things. So join me. Join me in pushing for peaceful noncompliance with invalid and void opinions. Peaceful noncompliance with laws and opinions that are void. Not my words, Alexander Hamilton's words. The words of the Supreme Court. So hopefully you found this interesting. Share what you've found. Share this video. Share the audio portion. Share the articles. Everything on the website's free for you to share. I hope you appreciate that. In fact, I hope you'll support the work that I'm doing. Go to constitutionstudy.com/donate. Everything you donate there goes to supporting the site and the podcast. The videos, the audios, all the software, all the hosting, all that is supported by those donations. So I hope you'll do that, and I hope you'll support the work that I'm doing by buying a book or getting a membership to the Constitution Scholar. Hey, ask a question, bring me out to speak to one of your groups. We can do it online or we can do it in person. I've been dying to get in front of more people. I love doing that. So if you can, reach out, let me know. I'm more than willing to travel if we can get the expenses covered, and I'm more than willing to work with you on making that happen. Most of all, again, share all of this. I hope you found enough value in it that not only will you read it, but you'll share it. You'll watch this video, you'll share it with others, and you'll come back here next time for the Constitution Study.
There's one thing you have to know wherever you make your stand. Came from